Many individuals choose to submit their own green card applications to become permanent residents. One of the reasons we started this channel was to provide valuable information to help improve the chances of successfully filing these applications. Whether you handle the process yourself or hire an attorney, our goal is to be a resource to make that decision easier. Today, we'll discuss 3 common mistakes people make on the latest version of the green card application, which was recently updated. There are 3 specific questions applicants need to better understand. The current environment allows USCIS officers to deny applications for minor technicalities or, in more serious cases, for fraud or misrepresentation. We've covered some of these topics before, but since many new viewers have joined, we'll briefly review them again. Additionally, we'll introduce a 3rd mistake unique to this video. Please like this video, subscribe to our channel, and hit the notification bell so you don't miss any U.S. immigration updates. Let's dive in. The first 2 mistakes relate to questions 12 and 13, which appear midway through the green card application among a series of yes or no questions. These ask, have you ever worked in the U.S. without authorization? Have you ever violated the terms or conditions of your non-immigrant visa? Starting with the non-immigrant visa question, if you've overstayed a tourist or student visa and are now married to a U.S. citizen, you've likely violated its terms. Overstaying is a clear violation, but even if you didn't overstay, forming the intent to live in the U.S. permanently, which is evident when submitting Form I-485, could require answering yes. This is because intending to stay permanently conflicts with the temporary intent required for tourist or student visas. Important note, this video specifically addresses marriage-based green cards and immediate relative petitions, not all family-based immigration categories. If you've entered the U.S. multiple times as a tourist and waited at least 90 days after your most recent entry before showing immigrant intent, such as marrying a U.S. citizen or filing a green card application, you're likely fine. However, if you previously entered with the intent to immigrate, such as by working illegally or planning to stay permanently, this could indicate fraudulent intent, a serious issue that may require a fraud waiver in the future. If you've never violated your visa terms and recently entered without taking actions that show immigrant intent, you're likely safe. In such cases, you might answer yes to violating visa. Now, regarding unauthorized work, if you previously worked without authorization, it could indicate a past visa violation, potentially suggesting fraudulent intent at entry. However, if you entered as a tourist years ago, worked illegally, and are now married to a U.S. citizen, unauthorized work alone won't disqualify you from getting a green card. What will disqualify you is lying on your application. For example, if you tell an immigration officer you never worked without authorization when you actually have, it raises red flags. Always disclose unauthorized work. If you're married to a U.S. citizen, it won't harm your application, but lying could lead to a fraud determination or denial. The 3rd mistake involves a new question on the latest I-485 form, question 76. This asks whether you have any unlawful presence in the U.S., and if you've ever departed after accumulating unlawful presence. For most applicants adjusting status through marriage to a U.S. citizen, the answer is yes if you've overstayed a visa or are currently out of status. However, if you're on a dual intent visa like an H-1B and remain in compliance, the answer might be no. This question is particularly important for preference category family petitions, but less relevant for immediate relatives. We made this video because many people are unsure how to answer these questions. Some worry that answering yes could lead to denial, but in many cases, it's necessary. However, there are nuances, and we recommend consulting an attorney if you're uncertain. Thank you.